Hello, I'm Vangela M. Wade, President and CEO of the Mississippi Center for Justice. Thank you so much for joining me today. Mississippi Center for Justice is a Mississippi homegrown public interest law firm, nonprofit public interest law firm. And we're committed to advancing racial, social, and economic justice across this state. The scope of our work is far-reaching. We have lawyers and advocates who are committed to consumer protection, public benefits and health, educational opportunities, immigration, and disaster recovery. Our George Riley Impact Litigation Initiative focuses on voting and election rights, reproductive rights, discrimination, and very important for us today, which is our topic for today, criminal justice reform. Joining me today is Rob McDuff, our director of the George Riley Impact Litigation Initiative. And today we're going to discuss the Curtis Flowers case. Over 23 years, more than 8,000 days, imagine that. That's how long Curtis Flowers, a Black man who was tried an unprecedented 6 times for the same crime, spent in prison on death row, Parchman Penitentiary. Despite the lack of evidence actually linking him to this case, and despite the gross misconduct of the prosecutor, Mr. Flowers spent over 23 years in prison. On Friday, Mississippi Attorney General Lynn Fitch moved to dismiss the charges against Mr. Flowers. So finally, after more than 2 decades, Mr. Flowers is free. The charges against Mr. Flowers were never grounded in fact, but rather fueled by improper conduct by the Montgomery County District Attorney, Doug Evans, the prosecutor in each of Mr. Flowers' 6 trials. MCJ's own Rob McDuff defended Flowers since the summer of 2019, joining a magnificent team of lawyers that he'll tell you about shortly, that had represented Mr. Flowers for some years. So I am thrilled today to have a chance to speak with Rob, and I've had to get in line, but a chance to speak with Rob about this monumental case and the dismissal as of Friday afternoon. So, I'm also very interested in hearing Rob's perspective on our criminal justice system going forward. So, hello, Rob. Thank you so much for joining me.
Thank you.
You know, we've been in just a flurry of activity and emotion, I will say, since Friday afternoon when we heard the news of Mr. Flowers' case being dismissed. I'd like to know from your perspective, and I've not had a chance to ask you this directly, but tell us, how did you feel? How did the team feel? And more importantly, what did you hear from Mr. Flowers and his family once they received the news that the case had been dismissed?
Well, we have for several months now been hoping and believing that the case would be dismissed because the prosecutor, Doug Evans, had withdrawn in early January, 3 weeks after bail was granted and Curtis was released from prison after 23 years. He had withdrawn in the face of our motion to recuse him. The incoming Attorney General Lynn Fitch was appointed to take his place. She had a team of very good lawyers reviewing the case. They reviewed loads and loads of records and transcripts. We submitted material to them. We had a conversation with them. I know they interviewed the district attorney as well, Doug Evans. But we felt like once an independent and thorough and fair review was done, the only conclusion that could be reached was that the charges should be dismissed. So we've been believing it's going to happen for a while. It was taking a little longer than we thought it would not for any particular negative reason, but it's a big case. It took a while to review. And Curtis was hoping it was going to happen too, and believing it was going to happen, but it was still a bit of it. The suspense was that the anxiety was actually beginning to take a toll on him, because he was just waiting and waiting and waiting. So, I had the sense in the middle of last week that it might happen on the Friday before Labor Day. And we actually scheduled a call with Curtis that afternoon to update him. We didn't tell him what our suspicion was, but we scheduled a call to update him. And then mid-afternoon Friday, we confirmed that it was happening. And all of his lawyers gathered on Zoom with him. And he was just relieved and elated and just very, very happy, as were we all, because even though we had felt it was going to happen, it was still just a great feeling to finally have this cloud lifted off of his head after 23 years. Of course, he'd been out on bail since December, but it was just it was a wonderful time. It was a wonderful evening. We sort of all went on and off of Zoom for a couple of hours visiting and talking, and it was a great thing to finally happen.
Yeah, I can imagine just the elation that he must have felt, and his family more particularly. I had mentioned to you earlier in the week that that the fact that his mother passed away during the course of this horrendous injustice or prolonged injustice just made it even more tragic for me. But I heard you say in one interview that he talked about his mother looking down and smiling now that this has come, what she believed all along has now come to be. So that in and of itself just gives you a little more joy in what must seem a very tragic situation.
And his wonderful father, 77 years old, is still alive. He was actually there in the courtroom during the bail argument and heard it when the judge granted bail, and he obviously was just very happy about this, and his brothers and sisters, and it's a wonderful family that has supported him through this time, and has really he issued a statement after this saying he owes a lot to them, because he was really able to get through this because of their support.
And Rob, you mentioned, and of course, most folks know that, of course, there are a lot of issues with this case, and the fact that, of course, as we've mentioned before, that it was an unprecedented 6 trials, one person, same crime, same charges. What were the flaws that should have been apparent in this case?
Of course, there was the discrimination in jury selection that was committed by the prosecutor, and that ultimately was recognized by the U.S. Supreme Court when they vacated the conviction for less sentence last summer. The 6th trial, where they said he had engaged in evidence of prosecutor engaged in some internal effort to hold the jury back just to prove these trials. And as a result, when he did that pretty much guaranteed a conviction. Whenever there was more than one black juror on the trial, there was a mistrial, as in the trials. But in the 4 where there was 1 or 0, it always ended up in a conviction and death sentence. But the other problem was just the failure to disclose exculpatory evidence, such as the existence of alternative suspects. They had always said there were no alternative suspects, but there were, and that was eventually uncovered. But the real flaw in this was a tunnel vision at the beginning, where they just settled on Curtis Flowers because he was sort of an easy target. I mean, he had, when this crime happened, they were told that Curtis Flowers had worked there a few days and then had been let go because of the destruction of some accidental damaging of some equipment. But this was a case where this was a brazen robbery on a weekday morning in a downtown furniture store in a small town, Winona. The 4 people who were killed in the course of that robbery were killed with precision shooting. 8 days earlier, at night, someone broke in through the roof into that furniture store and tried to crack the safe. They were unsuccessful. They left through a side door and took a key that was hanging by the side door, the key to the side door with them. No one ever investigated the link between those 2 crimes.
Mm-hmm.
And it's pretty clear there was a link, but whether there was or wasn't, the murders were committed by a professional criminal. And here they hear this thing about Curtis Flowers getting fired. And of course, a lot of people get fired from jobs. They don't react by going
and murdering,
killing people.
Yeah.
Right. And they followed up on that. Instead of investigating potential suspects who had criminal histories, they focused on Curtis Flowers, who was 26 years old and had absolutely no criminal record and nothing in his history that would suggest he would have the inclination or the ability to commit a crime like this. But once they settled on him, that was it, and they ignored evidence of other suspects who had criminal histories that made them much more likely to be suspects than Curtis Flowers. And it just went on from there. They pressured witnesses. They did favors for criminals, including a career criminal, Odell Hallman, who claimed Curtis confessed to him, and it just went on and on.
And I'd like to ask you about before, and I want to make sure that we do get into the whole Batson challenge or excluding particularly African Americans from the jury. But before we talk about that, let's talk about this career criminal, Mr. Holman, and the role that he played in this, along with the DA, in this tragedy.
Oh, it was really horrible, and he claimed that Curtis Flowers was bragging to him when they were in prison in Parchment together. I mean, Odell Hallman had a mile-long record of violence, a record of drugs, a record of robberies, and the one thing is when we at the bail hearing, I was pointing out to the judge the fact that Curtis had no criminal record when he was arrested, and that he had a spotless prison record for 23 years. He had one minor disciplinary infraction, which is just really difficult to do in a prison.
And after 23 years, I imagine it should be even more difficult.
There's so many conflicts in prison, and it's just the deputy commissioner of corrections at the time, when Curtis was in there most of that time, he gave an affidavit and said, "This is one of the best prison records I've ever seen." And it's really difficult to do that, which just shows you Curtis is not the kind of person who would have committed this murder, and certainly not the kind of person who would be bragging to the likes of Odell Hallman that, "Oh yeah, I committed this murder." And so the whole thing was just preposterous. But Odell Hallman got break after break after break from the district attorney, Doug Evans. Evans did not disclose many of these breaks to defense counsel because they could have used that to impeach Hallman and to call his credibility in question. And the remarkable thing is he did him so many favors that even after the 6th trial, Hallman got arrested for trying to run over a police officer who was who was about to stop him, and Hallman had drugs in the car. Tries to run over the guy, eventually gets arrested, put in jail, and a few months later, Doug Evans agrees to bail for him in the amount of $25,000, which is just unheard of for a guy with that kind of record who's tried to run over a police officer. Bail is granted. And Odell Hallman, a few months after that, kills 3 people. So I mean, it really was a deal with the devil, and it just, but all this favoritism was done simply because of Hallman's cooperation in the effort to railroad Curtis Flowers.
Is there any indication that Mr. Flowers, were there any witnesses? Maybe that would be the question. Were there ever any witnesses that saw Mr. Flowers in that store taking any aggressive action toward any of the persons who were in the store? And then how long after the murders did it take for the DA or the police to start focusing on Mr. Flowers?
No, there's nobody who saw him. There were people who later, after being pressured by the police, who said, I saw him downtown near the store. There was another who vaguely said, I saw somebody, this looks like him. But before that, they'd said it looked like a guy named Doyle Simpson, who is one of the prime suspects in the case, and whose gun apparently was used. Yet they focused on Curtis and said he had, with just a preposterous story about him stealing the gun from Doyle's car. But yeah, it was just they focused on him in the first, I would say, month or so, when the people there talked about how Curtis had been fired for this, accidental damage to property. And they just kept going back to Curtis, and it just turned out to be it's just crazy, but I guess that was sort of the path of least resistance for them, instead of really investigating this case and really looking into the people who would have been much more likely to commit this. And this occurred during a big crime wave in Montgomery and Grenada counties. So there were a lot of suspects, one of whom was Doyle Simpson's cousin, who committed a bank robbery, another number of commercial robberies, another cousin who'd actually tried to break into a building through a roof. But they didn't do the really hard detective work that would have been necessary in this case. Instead, they just focused on Curtis.
All right. So it was with this information that was later just uncovered, because as you mentioned, it wasn't this potentially exculpatory evidence was not provided to the defense by the prosecutor, but it was this information, these other potential suspects that were provided not only at for the bail hearing, but also for the Attorney General to review. Is that correct?
That's right. And there had been, the case, Curtis Flowers should never have been charged in the first place, for reasons I already mentioned about how this is clearly the work of professional criminals. Here's a guy, 26 years old, with no record, nothing to suggest he would do something like this or could do something like this. But they obviously took him to trial 6 times. And since the sixth trial, as it was going through appeal, there was a lot of investigative work done, in part by the American public media reporters for the In the Dark podcast that focused on Curtis for season 2. We can talk more about that in a minute. Also by the tremendous legal team that represented Curtis on the appeal since that 6th trial. It includes the Cornell Law School Capital Punishment Project, Sherry Johnson and Keir Weibel, who are professors there and who are just wonderful capital defense lawyers who handled his appeal. The law firm, the DC office of the Hogan Lovells law firm, got involved around 2015 and working with Tucker Carrington of the Mississippi Innocence Project, thoroughly investigated the case and prepared a post-conviction petition to be pursued in the event the appeal didn't work out. So they've done a lot of work on the case. And so when I was brought in to sort of lead the defense for a potential 7th trial after the case was sent back from the U.S. Supreme Court. I had the great fortune of working with all these wonderful lawyers who had done such great work on the case, and the fruits of their investigation, plus the fruits of the In the Dark investigation. And by the way, we recruited another terrific capital defense lawyer from North Carolina named Henderson Hill to be co-counsel with me back in the trial court in Montgomery County. But it was just, and all of this investigation led to more and more evidence of innocence. Recanted witnesses who recanted and admitted they had been pressured. Odell Hallman finally admitted that he had been lying all along. He said it was make-believe, it was a bunch of fantasies. And so we really came into the bail hearing with the case looking very different than it did before. Mm-hmm. The judge pointed that out when he granted bail. And then we were able to present all of this to the Attorney General, who fortunately was taking a fresh look at it because Doug Evans had withdrawn in the face of our motion to recuse. And she came to the right conclusion.
And, as you talk about and you lay that out, and you see there were so many opportunities for the prosecutor to either consider other potential perpetrators, go a different direction, and especially after, let's say, the second, the third, the fourth, the fifth trial. I know that there were, at least a couple of those where there were issues with him purposefully striking African Americans from the jury. Would you speak to that and explain what it means to have a Batson challenge and how that can impact clearly the outcome of a trial?
Oh yeah, and in these 6 trials, in the 4 cases where there was either no Black people on the jury or only one, there was a conviction and death sentence. In the 2 cases where they had more than one Black juror, it was a mistrial, and the jury couldn't agree. And this was, I also should mention the lawyers who represented Curtis in the last 4 trials were from the Mississippi Office of Capital Defense Counsel, Ray Carter and Allison Steiner and Andre Degree, who labored mightily in the defense of Curtis, but they were really handicapped in part because Evans didn't turn over all the evidence. Right, and didn't admit that they had these other suspects and was striking Black jurors and giving reasons for the strikes that just weren't true. And so anyway, it was a difficult situation, and Evans really stacked the deck against Curtis, and it was just a really unfortunate situation. And once you had a diverse jury, the result was different. Now, had you had a diverse jury with all of the evidence out, I think he would have been acquitted. At the first trial or one of the subsequent trials, but it was just a really unjust situation.
So you have not only the miscarriage of justice on the outcome with regards to Curtis having served 23 years of his life behind bars for a crime that clearly the evidence supports that he did not commit, but you also have the injustice of a person charged with ensuring justice of a process, meaning the prosecutor, withholding evidence, violating legal standards and the law, but really violating the sanctity of the justice process for the jury, for those people who would commit themselves to participating in that process as jurors, expecting to receive truth and particularly from those folks who are charged with doing this, such as a prosecutor. So you have a miscarriage of justice across the board here. Not, certainly we understand that for Curtis and Curtis's family, but also for those folks who served on those juries, and for the families of those folks who were indeed murdered. That this extends, that this miscarriage of justice perpetrated clearly by the prosecutor in this case extends far beyond Mr. Flowers.
Oh, that's exactly right. And it's just it's but it's funny how opinions have changed since the podcast and since In the Dark, and you have there's some people who are always going to believe Curtis did it, and it may well be that some of the family members of the people were killed think that, because they've been told that so many times and they saw so many convictions, right? But they weren't fair convictions. They weren't valid convictions. And if all of the evidence had been presented properly to a jury, I don't see any way a conviction could have been obtained. And I think he would have been found acquitted a long time ago. And of course, as I said earlier, case should have never been brought. He should have never been charged. And so it's really it's a long and tragic injustice, and it's great that it's finally over. But boy, first he's had to pay a price, and others did as well. But nobody had to pay the price he had to pay.
Right, and I as I think about the price of, certainly, that Mr. Flowers has paid with his life, and of course his family, but I also think about other people who've been charged in the same manner with regards to a prosecutor being overly zealous to achieve an end as opposed to achieving justice. And I know you've worked on other cases involving similar prosecutorial misconduct or withholding of evidence prior to Mr. Flowers. So how common is this, Rob, in Mississippi, across the nation?
I mean, we've certainly got some cases you can point to in every state, including Mississippi, of unjust prosecutions of innocent people where exculpatory evidence was withheld, where there were unconstitutional efforts to keep Black people from serving on the jury. So it sure happens. I don't know. It's hard to quantify how much it happens. And maybe there are probably many cases where it hasn't been uncovered yet. Mm-hmm. Because it's tragic that this happened, but fortunately for Curtis Flowers, In the Dark came along. And he had this wonderful team of lawyers. And I neglected to mention the people from the DC office and the law firm, Jonathan Abram and Katie Alley and David Maxwell, and a wonderful paralegal named Ashley Johnson, and so many others from that firm, along with the people I've already mentioned. And there was just enormous amounts of time and resources poured into this case. And because it had 6 trials, I mean, if it had only 1 or 2 trials, people may never have heard of Curtis Flowers. And so it's, fortunately, we found out this one, but there's some problems with the system that can lead to a result like this.
Right. And but for, as you just mentioned, certainly the tremendous work by the defense team, but also by In the Dark, American Public Radio.
Yeah.
How do you think that the podcast, I've listened to it and it is gripping, to say the least. I never thought that I would put that much time into listening, but you can see it unfolding each time they interview, some alleged witness, and how the people will recant or say, I had no idea that this was going to happen, or that was never my intention. Even their conversation with Holman, as well as they're trying to get conversations with Doug Evans over a period of time. But it is just gripping. There was other work. They in their investigation, they uncovered over a decade or so other criminal cases led by Doug Evans, where there was evidence of African Americans being stricken from juries. How helpful do you see their work in this outcome?
Oh, it was just extraordinarily helpful, and you know, they shined a light on this case. You know, their work was already public by the time the U.S. Supreme Court took the case. I don't know if somebody had become aware of this case because of that. Certainly the petitions had been filed, and the Supreme Court may well have taken it anyway because it's such an unusual and a case of such an enormous record of racial discrimination in jury selection. But it really alerted people to what was going on, and the incredible investigative work they did is just wow. They were in old warehouses, looking through old court records that were from years and years earlier.
Which goes to the point that there's for much of this, the evidence or the information that's compiled to show sort of a history of actions by prosecutors, in particular this Montgomery County, but I believe that may be the issue across the state, that there are very, very few databases of whether it's jury information or actions taken through the course of trials. Is that your experience? Yeah,
that's right. And there's so many, so many records that can get lost. I mean, the investigators did a terrible job of documenting what happened in this case. And there was no overall police report. They interviewed a suspect at the time named Willie James Hemphill, who was uncovered by In the Dark. They didn't uncover, I mean, there was a lot of work also done by the law firm uncovering witnesses, but In the Dark tracked down Willie James Hemphill. But there were no records of the interviews with him, even though he was held in jail for 11 days. And so they were dogging in their pursuit of what went on in this case. And, and they told the story so well in that podcast that really changed the public outlook on this case. And just of immense value, the work they did.
Absolutely. Rob, our nation is undergoing really a massive reckoning on racism. And this is, as we moved through this month of August, through the anniversary of the murder of Emmett Till, even his murder having occurred on August 28th, 65 years ago. So we're just, moving through that process when his mother would have demanded that he have an open casket funeral, and those pictures published that we all so vividly can recall. And then of course we've got George Floyd, and now we have Jacob Blake and Breonna Taylor, Ahmaud Arbery, and the list goes on and on. So we know that in the last few months, the veil has been, certainly pulled back on our, whether it's our policing or the justice or the lack thereof in many of these murders. But it's clear that racism played a huge role in the Flowers case. Are you hopeful that what we're seeing now, not only with Flowers case, but this movement toward people wanting more transparency in law enforcement, in the judicial system, wanting uh, to purge our country of racism? Are you hopeful that this will have a positive impact on our criminal justice system?
Well, I hope so. There've been so many times when there've been modest improvements made in the situation, but we're still in this. Still, the whole society is still in this real. The consequences of 400 years of racism that are still with us, and you still got such differentials in income and living conditions, everything else in America, and it really has infected the criminal justice system. There were some improvements. Have been improvements in recent years with situations surrounding money bail and surrounding debtors' prisons and the real impact things like that have had on Black people in Mississippi and elsewhere. And so improvements are being made, and I hope they're going to be more made when we look at cases like Curtis Flowers' case in this real time of reckoning. But you've got to have good people in charge in the positions of power, and so we need more good district attorneys. Doug Evans, as you know, was elected unopposed, re-elected unopposed back in November, even though there was a great effort to get someone to run against him.
And he's been in office for over 20 years. And it's my understanding that there's really never been any real opposition.
That's right. We do have some, over in the Columbus area, a wonderful Black lawyer named Scott Cologne defeated a white district attorney who had a real bad record and had sent at least 2 people and actually more to prison, named Forrest Allgood. Now he claims he didn't do it intentionally, but a lot of people think he really cut corners. And then recently, Jody Owens, who was a former director of the Jackson office of Southern Poverty Law Center, a wonderful, terrific Black lawyer, was elected district attorney in Hinds County. And so we need more people like that running for district attorney. We need more good people becoming assistant DAs because they have such immense power. We need judges who are being more careful to make sure the process is fair. We need a statewide public defender system, so we have full-time public defenders. In most areas of the state, the public defenders are part-time. They have private practices. Some are great. Some cut corners. And of course, there are some good prosecutors in Mississippi and elsewhere, and it's wonderful to run into one, to work with one, people who are fair and who really can discern cases that should be brought and cases that shouldn't, who believe in proportional punishment and who believe that mercy is a good thing on many occasions. And we've got to make sure there are good people working in the system. Now, there's another thing we were talking about juries and the problem with discrimination in the selection of juries. Right now, the rule is that a lawyer should not intentionally strike somebody from the jury just because of their race. That is clear from the Flowers case. That rule has been ignored so many times, and prosecutors come up with excuses. Some prosecutors come up with excuses to get around that rule. What we really need is some kind of development in the law where a defendant is entitled to a certain number of jurors of his or her race. because we know race plays a role in the criminal justice system. We know it's a negative influence, and that it can send people to prison who shouldn't be there. And so we really need to balance the racial concern out by making sure that there are going to be people who are of the same race, because we saw it happen in Curtis Flowers' case. Every time there was over more than one Black person on the jury, there was a mistrial, and you didn't have a conviction. And that's just something, I mean, I think we're a long way away from that day, but it is something we really need to try to balance things out.
So what would you say, because that brought to mind, whenever a Black person is exonerated, or maybe not exonerated, but who goes through the criminal justice system or through a trial, and they're found not guilty, and where there are a large number of African Americans on the jury, sometimes people will allege that there's some type of nullification. Generally people will. I was reading yesterday comments to my op-ed on the Washington Post, and somebody mentioned, "Oh, this is just another OJ," because it mentioned that there were a couple of those trials where there were at least one African American, and those ended in hung jury. And the commenter immediately, I'm going to say, pull the OJ card to say, "Oh, well, that was just, Black person refusing to convict someone of a crime." So in the juries that or the cases that you've worked on, and including what you know about the Flowers case, was there any indication of an attempt at jury nullification?
No, and I think, certainly in the Flowers case, the people who held out during the two mistrials turned out to be right. They turned out to be right. He wasn't guilty, and the people who voted to convict him were wrong. Now, many of them were misled. They were misled by the prosecutor. They were misled because they didn't have a full evidentiary presentation. But lawyers, I've had Black clients get convicted by juries that included a lot of Black people when the evidence was there. And so I don't, I just don't think that's a big problem. I've seen, there are white people who get convicted by jurors with a lot of white people when the evidence is there. Jurors by white and Black people. We need a broad cross section, right, of society on the juries, and in fact, the Sixth Amendment guarantees that. But unfortunately, prosecutors get around it, and some prosecutors get around it, and some judges let it happen.
Right. And I would point out too that just as people have biases that they bring to any particular situation, and when a prosecutor brings his or her biases, prejudices, those can be filters through which they see the evidence, or filters through which they negate evidence, or refuse to offer equitable, plea arrangements for African Americans as opposed to whites. I spent a year in the DA's office in Madison County. And, I initially, at one point in my life, Rob, believe it or not, I envisioned myself as a great prosecutor, wanting to be, be on that side of justice to ensure that there was justice. That was enough for me to really reassess where I would be most beneficial. And it's my understanding that was way back in 1997, 98. And I don't believe there's been another African American assistant DA in Madison County since then. And That's been well over 20 years. So that may speak some volumes to folks, but where you can have a area that clearly has a substantial number of African Americans, and you not have one African American prosecutor, should raise flags. Rob, before we go, we have a few questions from in the Facebook chat. I want to see if I can reach those. So here's a question from your old Harvard friend. In this case, the highlight of your story, is this case the highlight of your storied career, Rob McDuff? And that's from Whitney Alex Barkley Denny.
Oh, was Whitney actually used to work at MCJ.
Oh.
Yeah, she's.
So is this the highlight of your career? Because you've had some really great cases and been involved in a number of cases. So would you say this is the coup de grace or the cherry on top?
Well, it is sure one of the highlights. I've been lucky. I've had a lot of interesting cases, and each one is different. But this is just been so wonderful to represent Curtis Flowers, who's such a great guy and such a great person. Obviously, an innocent person who has suffered greatly, and to work on the terrific legal team he had, and just one of the things really interesting, you were asking me earlier about In the Dark, and to watch sort of the transformation, even with just my year of the case, but having read about it before, and sort of the public perception about it that stemmed from In the Dark, and in large part. And one day when I was in Winona, when we were going to do our first filing of the bail motion, the motion to dismiss, I had some papers with me, and I was just in a commercial establishment, and the clerk saw my papers and she said, "Curtis Flowers." And I said, "Yeah." She said, "Oh yeah, I know about that case." And I said, "How do you know?" And she said, I heard the podcast about it." And she's a young white woman. And I said, "What'd you think?" She says, "Oh, I know he's not guilty." And I said, "Really?" And she said, "Yeah." I said, "Well, what do other people think?" She says, "Oh, my boss, she's the one who told me to watch it. She thinks he's not guilty. I told my parents to listen to it, and they're just old Southern people, and they think he's not guilty." And it was really quite an unusual experience being in northern Mississippi. And so it's really been special to sort of watch the public transformation.
Right.
In this case, and the judge, who was the presiding judge in the 5th and 6th trials, obviously recognized the changing posture of the case when he granted bail and talked about the lack of evidence. Right. So anyway, yeah, it's been a great highlight, just a wonderful personal and professional experience.
And I want to just I think it's important for people to keep remembering, and for us to reiterate that the juries, those 6 juries, did not have access to the evidence, to the full body of evidence. And so it could have been after, as you mentioned earlier, after the first trial, it could have been much different. So it was restricting, excluding that evidence from the jury, and therefore really from the defense, therefore from the jury, that really could have made a difference. That did make a difference in this trial. So so now that people are hearing the evidence, have that opportunity, I could see how the minds would begin to shift. Yeah. Let me check for other questions. I think Whitney she says that my understanding is that we have to actually exonerate Curtis to get him compensated for the years he has spent in prison. Is that right? And are there plans to do that?
There's a Mississippi law that was passed about 12 years ago that provides that people who spend their time, who've been wrongly put in prison, and who can prove by preponderance of evidence their innocence, that they can recover $50,000 a year for every year in prison, up to $500,000 cap. And so, I believe, we have been focused right now on getting these charges dismissed. So we really haven't looked at all of this in detail, but I do believe Curtis qualifies for that. And then you can also sue anyone who acted maliciously in causing him to be convicted, except that prosecutors have immunity. Like you can sue police officers. Prosecutors have immunity for what they do in their prosecutorial capacity. Now, if they're acting as investigators, that may be a different story. It's a really complicated area of the law. So we're going to be evaluating what Curtis's options are and talking to him about those.
Okay. And I think we have a couple of other questions. What will the state do? What will the state do to ensure that the DA does not continue this behavior? You just mentioned that there's immunity for, just like with police, that prosecutors have immunity. Well, with police, it's supposed to be a qualified immunity that has now been extended to what appears to be just absolute immunity. So how do we look at the prosecutorial, the immunity for prosecutors?
Yeah, and it's just a wrong-headed development in the law that occurred many years ago, so that prosecutors do have absolute immunity for what they do as prosecutors. Like you said, police have qualified immunity, which makes it easier to sue them, but it's still difficult. And Judge Carlton Reeves issued a wonderful opinion on recently on how misguided that whole doctrine is. So hopefully someday those things are going to change. But at least in this particular case now, Curtis's charges were dismissed with prejudice. And that means that he cannot be prosecuted again for these crimes. So we don't have to worry about, the district attorney coming back and charging him again, or some new DA down the road charging him again. And I just think, Attorney General Fitch and her office did a very, very good job in reviewing this case. I think she made the right decision. And I think most people, conservative, liberal, moderate, whatever, really understand what an injustice was done here. And I know I've had people of all political stripes, people of all races, tell me what they just think the result reached was here was terrible, and this was a real injustice. And I think I give credit to the Attorney General's office for doing a thorough and fair review and doing the right thing by dismissing this case.
Right. And just as we've talked about the jury, if the jury had the full scope of the evidence, it may have been a different outcome. I also, as you just said, want to give credit to the Attorney General and her office for reviewing all of the evidence, reviewing the trial record, the transcripts, and making that neutral, independent decision. So for anyone who's thinking or believing that there was still an injustice done here with regards to dismissing those charges against Curtis Flowers, I think all you have to do is what you should do is look at the fact that this Attorney General, the state Attorney General, reviewed all of what was available and presented this new evidence and made this finding. This wasn't something that the defense team came about. This was a neutral finding by an independent body. So, for anyone who's still skeptical, that is the point that we need to make here. Rob, we have one other question from, I believe this is from Johnny Ray. Do you think a book will come out of this case?
I don't know. There is a book to be written. I mean, there's a lot. This is obviously quite a long.
Is that a?
Oh, no.
Is that a cue? Are you working on one?
I'm no author. No, I have. I don't have plans to write a book, but it's just. I mean, it's what a long, winding road this case has been, and there's just and I've only been along for the last little bit of it, but it's quite a story of injustice, quite a fascinating story with twists and turns, and so I wouldn't be surprised if somebody wrote a book about it.
Absolutely. Absolutely. And before we go, Rob, we didn't. I don't think we really sort of focused in on how did MCJ become a part of this of Curtis's defense. How did you, on behalf of MCJ, come to represent Curtis?
Well, I've done a fair amount of criminal defense work along with civil rights work and some other kinds of cases as well over my career. And some of these have been sort of political type cases. I've represented one of the Gina 6 in Louisiana, one of the Angola 3, cases with numbers at the end. And, other cases of real injustices that were perpetrated against people. And I was, because of my criminal defense experience, they were looking for a new lawyer to work on the case in Mississippi after it came back from the US Supreme Court. Unfortunately, I was asked, and I agreed to do it. And I asked Mississippi Center for Justice, I asked Riley Morris, who was the director at the time, if MCJ would be willing to put the case under its umbrella, because although I still have my private practice, most of my time is spent on the impact litigation project for the Mississippi Center for Justice. And he agreed that we could take this as an MCJ case, and obviously MCJ has been very supportive throughout, and that's how I got involved in the case and how we got involved in the case.
And I am so appreciative of the work that we do at the Mississippi Center for Justice. And I sometimes people will say, when we talk about the various areas that we cover, I mentioned at the top of when we started at the top of the hour that public benefits, health, consumer protection, immigration, disaster recovery. We're boots on the ground right now dealing with just with COVID and what that means for the people across Mississippi and the various access to services and people who are facing eviction. So I am, this is the kind of work that we do, and I am so proud to be a part of this work and truly believe that we're standing in the gap for people who but for our organization and organizations like ours would not have representation and or access to resources. So I am proud to be a part of the same organization that you are, Rob. So thank you for joining me today, and for all of the people who are viewing us. And certainly we are ecstatic about Curtis Flowers and that he can now move on with his life after 2 decades of just gross injustice. This misconduct cannot be allowed to continue. Currently prosecutors are incentivized in some situations to secure the most prosecutions and to have the toughest sentences, in part because they face the potential for public outrage if they were to allow a guilty person to go free. But what happens when they are a part of a corrupt system that would incarcerate or charge a person who is innocent, such as with Mr. Flowers? So, I think it's important for us all to remember that ordinary people have power over prosecutors. Prosecutors are often selected through elections. So we need to make sure that when we go out to vote that we're checking before we get there. We need to check and make sure that who's on the ballot. Are there prosecutors on the ballot? Do we know what that person's record? Do we know what their background may be, so that we can make an informed decision? And even I think our civic duty greater than that is that when you are called to serve on a jury, don't try and find a way to get off the jury. I have sat in the courtroom and witnessed, even when, as a prosecutor and just as a person sitting in the jury pool hoping to get chosen, people finding every excuse under the sun as to why they should not or cannot serve on a jury. And unfortunately, many of the people that I have witnessed have been African American, trying to find a way off the jury. So I would beg you, if you want to see justice, you've got to be a part of justice, which means that we all have to play our part. We all have to do what we can to make sure that the system is fair. And that would include voting, that would include making ourselves available for the jury system. You know, another issue that Rob talked about and we talked about during this hour is that when prosecutors are unopposed, such as Doug Evans in Montgomery County all these years, he was unopposed. So if a person is unopposed, and that almost gives them a feeling, one may think it gives a person a feeling of power that can't be challenged. So I would certainly urge people to challenge where you see, particularly where power has been misused, that we, particularly members of the bar, we have a duty, I believe, to step in where we can, whether you win or not. So I will conclude by saying, you know, certainly Mr. Flowers spent more than 2 decades behind bars, largely and maybe primarily due to prosecutorial misconduct. No one else should have to suffer that injustice. So thank you again for joining us. Thank you, Rob. Remember, everyone, remember that no one else is coming to save us. We are the they that we keep talking about. You are, I am, we are the they that can make a difference. We can bring about change. We can bring about change. We can stop injustices, and we can stop the wrongs, not only in our state, but our country. So I hope that you take this opportunity to go out today, beautiful day, and find some good trouble. Find some good trouble, and let's make a difference. Thank you. Oh, how could I forget? I want to make sure that, and Rob, you should have pinged me on this. We want you to join us in our fight. We want you to join us at the Mississippi Center for Justice. Please go to our website, www.mscenterforjustice.org. Look at our work, and even more importantly, please join us by partnering with us. Please make your donation to help us continue the fight, not only for Mr. Flowers, but other people across this state who need us, who need the resources that MCJ and our partners can bring to bear. Thank you again, and have a wonderful day.